Honorable, the judges of the United States Court of Appeals of the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. Happy to have everybody with us today. We'll start with our first case, 23-2023, Allegis Group versus Bero. Mr. McDonald, we're happy to hear from you.
May it please the court. We're here on appeal because the district court misapplied the law to three provisions in an employment agreement. The first provision was a non-solicitation provision, which prevented the appellee, Mr. Bero, from soliciting certain covered clients of the appellant, Allegis Group, and Aston Carter. The second provision was a non-disclosure clause, which forbid Mr. Bero from disclosing, using, or otherwise divulging the company's confidential information. And the third clause was a return clause. That clause required Mr. Bero to return all company records at the end of his employment. The district court's errors of law in this case matter not only for this case, but for Aston Carter's entire business, which has been under sustained attack from a competitor seeking to poach its employees and drain its confidential knowledge base. I want to start with the non-solicitation clause, because that clause was the subject of much of the litigation below. The district court found that the non-solicitation clause was overbroad as a matter of law because it covered two categories of clients. Those categories of clients were first what I'll refer to as confidential information clients. Those were clients about whom Mr. Bero had received confidential information during his employment, but had not personally contacted, or had not necessarily personally contacted during his employment. The second category of clients for which the district court found the clause was overbroad were what I'll refer to as potential clients. These were clients about whom, or with whom, the company had not yet contracted during Mr. Bero's employment, but for whom Mr. Bero had participated in a bid or a solicitation or some similar kind of communication. Let me start with the confidential information clients. The court found that Aston Carter had no protectable interest under Maryland law for preventing Mr. Bero from soliciting that category of clients. And the district court reached that conclusion by reasoning that the only protectable interest under Maryland law for enforcing a non-solicitation provision is to protect customer goodwill, which is essentially the good feeling that the company has built up with a particular client over the years. The district court reasoned that if Mr. Bero had not personally contacted a particular client, he couldn't have built up any goodwill with that client, so the company had no protectable interest in preventing him from soliciting that client.
Mr. McDonald, could you address the Seneca 1 and why that opinion isn't controlling?
Yes, Your Honor. So Seneca 1 doesn't control in this case for two reasons. One, Seneca 1 is, of course, a federal district court sitting in diversity, and federal district courts sitting in diversity don't create Maryland law, they merely predict or apply Maryland law. So even if Seneca 1 had purported to pronounce some rule against soliciting this particular kind of client, it couldn't have done that. All it could have done is predict what Maryland courts would do. But more to the point, Seneca 1 is distinguishable on the facts in the sense that the clause in Seneca 1, the non-solicitation clause, was much broader than the clause in this case. That particular clause applied to clients, did not have the same tie to clients about whom the employee had received confidential information, or for the potential client's issue, did not have the same tie that required the employee to have participated, or excuse me, the language in our agreement is involved in, have been involved in a solicitation of those potential clients. And so on the facts in that case, the agreement was much broader than the agreement we have
And what's
here.
your best Maryland case to help your argument?
Rule is the best case, Your Honor. Rule v. Bartlett-Trico. That is the case from the 1960s, which recognized that employers in Maryland have a protectable interest in protecting their confidential information. We cite other cases in our brief, more recent cases. These are also federal district court cases applying rule and the general principle under Maryland law, but we think that principle is relatively well established, that employers in Maryland do have an independent and legitimate interest in protecting their confidential information. And the reason that's true, if I could offer an example or an illustration, the reason we need a provision that protects confidential information beyond goodwill built up by the employee through personal contacts is this. If Mr. Bero or any employee were to receive confidential information, he or she would be in a position after his or her employment to undermine the employer's investments in those confidential or that confidential information, regardless of whether he or she had had contact with a particular client. So Aston Carter's in the staffing business. And in the staffing business, one of the services Aston Carter offers its clients is it will place an employee with a client for a fee, a charge, and then it will pay the employee compensation for that placement. The difference between those two numbers is what's commonly referred to as a spread. It effectively represents the company's gross revenue for that particular placement. If Mr. Bero or some other employee subject to this agreement had been exposed to spread information about a particular client, he would be in a position, if he went to a competitor, as Mr. Bero did in this case, to immediately undercut the company just by knowing that spread information. He would be able to undercharge by $1 and take that client away. And that would be true even if he had never...
But isn't Mr. Bero, his clients, I guess, would have been, or his spread would have been human resources. And when he goes to JobBot, who is he trying to attempt to place are data scientists, engineers. How do you explain that that is not the book of work that he had when he was working for your company or the company you represent?
Yes, Your Honor. Two quick responses to that. One, on the confidential information piece, Mr. Bero could have had access to confidential information about employees for whom he would not have placed personally when he was with Aston Carter. He could have had access to that information.
Why do you keep saying he could have? Right? I mean, we're sort of in a different spot, and maybe we're talking about two different things, but the challenge I'm seeing is that, like, he could have had lots of things, right? But what I'm having a little trouble figuring out is, like, what you think he actually did here that was a problem? And why? I mean, I understand in theory, but we don't deal in necessarily in sort of broad theories, and we can talk about whether that's like the right way to think about this in some context or another. And we might imagine really hard edge cases. But why do we think that he had spread information here that was pertinent? I mean, that's your obligation to sort of prove that he had confidential information, and that meant he could not solicit for that particular job. I didn't see that, and so maybe help me understand why this spread information is a relevant discussion for us.
Yes, Your Honor, of course. The reason I'm using this sort of modal verb could have is because the district court, in addressing this confidential information piece, addressed the question as a matter of overbroad on its face. It wasn't looking at what had actually happened in this case. It was just saying that Aston Carter had no interest, regardless of the facts in this case, in enforcing that kind of provision. In this case,
but that only matters. I mean, at some level, that only matters if we've got some sort of a breach, right? And I understand your objection that we got to look at whether it's overbroad as applied here. We don't typically look at contracts whether they're overbroad in concept. It's not like a First Amendment inquiry. We ask, is it overbroad in some way that might apply here? So help me understand why this, I guess I'm just not sure why this spread information is relevant at all.
It's relevant only in the sense that when we're thinking about whether the contract is overbroad in general, on its face, in the mode of analysis the district court applied here, whether the company had any protectable interest in having this agreement at all. On the facts here, Your Honor is absolutely correct. The information that was at issue in this case wasn't spread information, it was in fact client lists. What Mr. Bero sent to himself were lists of clients that he had solicited.
Okay, but you're talking about the solicitation piece. I got the disclosure piece is a different story, but on the solicitation piece, which is, I thought where we were, help me I mean, there's no evidence that he had spread information that helped him in some context with any of the two alleged breaches that you're talking about?
No, Your Honor, he did not use spread information in those two specific
Okay,
breaches.
so tell me, what is it that you allege that he had, or why was it that he could not address those two particular clients?
Absolutely. So with respect to the particular two solicitations he made after leaving his employment, those were to Dave.com and Schneider Electric were two of his former clients. Now, the district court concluded that he didn't even put aside this question about whether the clause was enforceable in general, the discussion we were just having. The district court found he didn't violate it because those two placements that he was soliciting for were outside what are called his verticals. That's just parlance for the kind of placement he would have done while he was with.
Yeah, they're totally different jobs.
Yes.
Yeah.
Our argument below and here is that that analysis was wrong and misread the contract, because there is a second paragraph within that contract, 4A II, which forbade Mr. Bero from any solicitation that would have reduced the company's business in general, not just within his verticals. There's a separate paragraph that applies to this kind of scenario.
But did you argue that below?
We did, Your Honor. We
Because
argued that
I'm
Mr.
looking at your AII, I'm looking at your, the complaint below, and I don't see where that was argued below. I'm not even sure if it was pled below regarding AII.
So
So
the
if you
pleading,
can direct me as to where to find that.
Your Honor, the pleading below, specifically, what the company argued below was that.
Can you
Mr.
tell me where you are, where we are in the J, if I'm looking at the complaint?
So I don't have that page in front of me, Your Honor. I apologize, and I will,
Can you can tell us, but can you bring it to us when you come back up?
of course. Your Honor.
Because it's not helpful to us if we don't have like where we're supposed to look to confirm, right?
I understand, Your Honor. And to be clear.
So, but help us understand what that argument is, that if he was working on a job that he had had no information about or no contact with, you think he's still prohibited? In what way?
There is the second paragraph of that the non-solicitation provision, Your Honor, addresses this scenario. And what it says is that Mr. Bero is forbidden from soliciting any client for the purpose of reducing the company, broadly defined as the company group's, business with that particular client.
For the purpose of, so this is like a subjective inquiry into Mr. Barrow's mind?
Your-
For
that-
for his purpose, so he's only doing it to hurt your client? I mean, your client's complicated here, but Allegis?
It's not necessarily not a
And
harm.
so that would be that he couldn't do anything that might reduce Allegis's income.
That would have the effect, Your Honor. The language in the contract, excuse me, let me be a little more precise. The language in the contract does suggest a purposive inquiry here, and
And what evidence did you put in that Mr. Barrow's purpose was to reduce your client's income as opposed to increase his own income?
well, there's no dispute that the company group broadly defined could have filled those particular positions, and so the natural effect of that solicitation.
But Allegis wasn't doing that work. I don't know, what's the evidence that Allegis was otherwise competing, as you want to keep saying, in that vertical space?
Your Honor, the broader company group, Aerotek,
No, but you mean a
yes,
different
Your Honor.
company?
Yes, Your Honor, within the company group, so company within the agreement.
So
is
you
broad-
think AII says that any affiliated company, if this is going to hurt any affiliated company in any manner, that he's prohibited from doing it? So that would include, I take in your example, that hypothetically, if he went out and found a totally new client that Allegis and all of its people had never heard of or had any dealings with, he had no information about whatsoever, but that is a potential client in some totally abstract sense from Allegis, that he could not like go do business with them? I don't read A to I that way at all.
No, Your Honor, and if that's what I suggested, I apologize. What
You
I'm
said if it had any effect on any of its affiliated entities, then he's prohibited from doing it. That would suggest he literally can't do anything. Like,
Understood, Your Honor. But the client in this scenario would have to fit the definition of covered client. So it wouldn't just be any potential client. It would have to be a covered client under the definition of the contract, for one. And two, the company, broadly defined in the agreement, does include the affiliates of the company. So if an affiliate had a covered client and Mr. Bero solicited that client in a way that reduced that company's business with that client, that would be covered by 4A to II.
potentially reduced it, right? Not actually reduced it. And so, all right, so help me understand, what is the evidence that you put on or allegations you put on that this data scientist position was something that an affiliate was otherwise going to do? Just to use the Dave.com example?
Dave.com did do business with Aston Carter.
All
It
right.
was a covered client. There was a factual finding by the district court that found that it was. And there is no dispute that the company group could have filled those data scientist
Right, but
positions.
you keep using could have, right? Tell me, what is the allegation or evidence you put in that it did work in that space, or there's some reasonable likelihood that that's work that they would have otherwise gotten, right? I mean, it can't be just in the abstract, but we could have gone and done this other business. All right, fine, but that can't fall within AII, assuming it's raised at all, right? You got to have some allegation or evidence that that is work that you at least plausibly could have otherwise had, right? It's just like the fact that you allege to me today that you could have doesn't seem to get us very far.
No, Your Honor, and that's not our argument. Our argument was that the company group, broadly defined, did fill data scientist positions, and not necessarily Aston Carter, but Aston Carter's affiliates.
Okay, and what is the record site for that proposition?
I will look for the page, Your Honor.
Okay. And can you tell me what context it was in? Did you put in an affidavit, or was that, what is the basis for that? I mean, even if you don't have the record site, in case you can't find the record, can you point me to anything, or should I just go read the JA to try to find it?
No, Your Honor. We think that the argument in this case was essentially that the company group could have filled that position. That's essentially.
That's the argument. I understand that. The company group could also, like, launch rockets into space. What I'm asking is there any record support for the idea, other than you, no offense, having the allegation that they could do it? They could, start doing rockets too. I totally get that they could. What I want to know, was there any allegations or evidence that supported that, like, supposition?
Not specifically to my knowledge, Your Honor. If I could very briefly just move on to the non-disclosure clause. The non-disclosure clause in this case forbid Mr. Bero from using, divulging, or otherwise disclosing the company's confidential information. The district court found that that provision was overbroad for two reasons, one of which was that it attempted to protect trade secret information or beyond the definition under the Maryland Uniform Trade Secrets Act. We think that was a legal error because it contradicted the plain language of the Maryland Uniform Trade Secrets Act. The MUTSA in Section 1207 states that it preempts certain state law claims. Section 1207B, or subsection B, then carves out certain actions that are not preempted. That subsection lists claims under a contract. And so the statute itself contemplates that parties will continue to contract to protect non-trade secret information, and that they will bring actions similar to the, Your Honors, I see that I'm out of time.
You've reserved some time for rebuttal.
Thank you, Your Honors.
Mr. Fink, we're happy to hear from you.
Good morning. May it please the court. My name is Ben Fink, and along with my partner, Jeremy Kahn, we represent the appellee, Christopher Bero, in this case. Judge Hollander's well-reasoned 88-page decision should be affirmed for multiple reasons. This is a case about what a contract actually says, not what appellants wish they had written. First, Judge Hollander correctly found that Mr. Bero did not breach the non-solicit. So the issue about the enforceability, this court doesn't even need to reach that. There is no evidence in the record.
Can you address your colleague's argument that this is, at least with respect to the data scientist, that this is AII, that somebody that somehow is affiliated with his client could have filled a data scientist position, and so your work on that was in violation of that provision?
Yes, Your Honor. First, as Judge Benjamin pointed out, they didn't even argue AII in the lower court, so they waived it. They've raised that for the very first time here on appeal. But even if they did, there's absolutely no evidence that Mr. Bero breached that provision. That subparagraph applies if the communication is with the covered customer, as Judge Richardson, as you pointed out, for the purpose of reducing or eliminating the business such customer conducts with Aston Carter. They, in their brief, they talk about diverting business. It doesn't say diverting. That's something they wanted to say, but it doesn't. It says for the purpose of reducing or eliminating. And there's absolutely no evidence in the record.
So is your suggestion that really applies if Mr. Bero was doing it for spite? So if he's calling up former clients and saying that Allegis is a bunch of crooks, right? And so I'm trying to reduce Allegis's income, but I'm not doing it in order to get my own?
Well, Your Honor,
I mean, for the purpose of reducing, I mean, that seems like what it's suggesting, right? That it's not for the purpose of making money myself, it's only for the purpose of hurting my former employer.
I certainly think that's a reasonable way to read the provision that they wrote. But even if you look at it from their perspective, and as you pointed out, Judge Richardson, there's no evidence in the record that Aston Carter, the company that he worked for, had any opportunity at all to potentially fill this position. This is a data scientist position. Aston Carter, as Judge Benjamin pointed out, is a company that does professional services, HR, and folks like that. So
what's your response to his argument that they have some affiliated company that does data scientist work?
First of all, this agreement does not apply with respect to affiliated companies as to this provision. But if it does.
And why is that?
Because the definition, as I recall, the definition here, it's the covered customer of Aston Carter, not of any company. Allegis is $1 billion company with tens of thousands of employees around the country. The idea that Mr. Bero cannot be involved in any way in making a placement at any company that some Allegis affiliate could potentially make, if that's what this agreement says, that's overbroad and unenforceable under Maryland law, because that goes well beyond, and I think it's important to look at what is Maryland law on this issue. Maryland law with respect to restrictive covenants, particularly a non-solicitation covenant, is that the covenant, a legitimate interest of the covenant is to protect the goodwill, not the goodwill of the company. And I think that's what my friend on the other side said. That's not what Maryland law says. Maryland law says it's to protect the goodwill created by the employee for the company. So the idea that Mr. Bero could somehow be harming Aston Carter, the company that he worked for, by having a communication with a customer that could potentially do business with one of Allegis' other affiliates is what would render this completely unenforceable under Maryland law if that's what the agreement says. Because that would not be in any way related to the only legitimate interest that Maryland law recognizes in this context, which is the goodwill that he created with the customer on behalf of Aston Carter. So turning back to the alleged solicitations, again, Judge Hollander correctly found that there is not sufficient evidence in the record to create a question of fact as to whether Mr. Bero.
Can I just go back to this to make
Yes.
sure I understand? With respect to AII, it refers to the company or any company affiliate which employed the employee during the look-back period. Your colleague suggested that included lots of other companies here within the broad group. Did your client work for anybody other than Aston?
He did work for Aerotek out in California before he moved to Tennessee.
And was that during the look-back period?
I think briefly, yes, Your Honor. But again, there's no evidence whatsoever, one, as to what types of positions Aerotek could potentially fill, or two, that the business from ETAP or Dave.com is business that in any way could conceivably have been Aerotek business.
So when he worked for Aerotek, he was doing something similar with HR placements and administrative type placements?
Professional services, that's correct, Your Honor. So turning to a couple of the other issues with respect to the non-solicit. As I said, the non-solicit, Judge Hollander correctly found the non-solicit is unenforceable under Maryland law. Maryland law is clear that the only legitimate interest to support a restrictive covenant, including a non-solicit of this nature, is customer goodwill that's developed by the employee during employment by the employer. And so here, this covenant goes further than that. This covenant applies to customers about which he supposedly obtained confidential information. If he has even if he did have confidential information about some other customers of Aston Carter, there's no way that he could take advantage of the goodwill that he created with those customers if he never had contact with them during his employment. Therefore, under Maryland law, it's
So
unenforceable.
your position on this is that even if I was in the back of the house, right, and so I had no contact with customers, right? So imagine I'm an employee, I work in the back of the house, but I know everything about them, right? I have all of the intel that this company has about a given client. Rates and payments and needs and all of those things. Your position is that if that client leaves, there can be no restriction on what they do, that they can use that confidential information in any way they want to?
No, absolutely not, Your Honor.
But that seems like the point you're making. If it's only, and maybe the judge below was making, if the only thing you can do is like your own goodwill, and there can be no protection of confidential information, then there's no non-compete for people who are not client-faced, right? So like anybody that's in the back of the house, no matter how much confidential information that they have developed, there can be no limit on it?
No, Your Honor. First of all, Maryland law allows the enforcement of a properly drafted confidentiality or non-disclosure provision. So this one is not, but that's the
No, but it's not
protection.
confidentiality or non-disclosure, right? What it's saying is, you can't take all the information you have now learned through us and use it to go compete to get that same client, right? That seems like a remarkable line to draw, to say that it's only, I don't see it in Maryland cases. I see it in the court below said it, but that seems like a remarkable line to say that confidential information can never be a basis for a non-compete, which is, I think, the import of the position you're taking.
Well, Your Honor, the issue there is that's an issue for the Maryland courts and the Maryland legislature to address. For example.
That's right, but we've said repeatedly, right? So the Maryland courts have not said that, right? I found no Maryland court that's taken that position. There's some federal courts that have suggested that, but I found no Maryland court that said it. And we say repeatedly that federal courts should not create or expand public policy. And I'm totally with you, right? If Maryland wanted to make that a rule, it seems like an odd one for them to choose to make, but that's obviously their priority. But it's not for us to create that where the Maryland courts have not. That's the rub that I'm having with that. I'm not totally sure why this matters. I don't think he didn't solicit anybody anyway, but I'm having a little hard time understanding why confidential information can't be and why you think Maryland law, actual Maryland case law suggests that that is the line.
Well, Your Honor, first of all, I agree with you that you don't even need to get to this because he didn't solicit.
I know, but you
no
brought it
evidence.
up, so I'm just responding to you, right?
But no, I think the answer is that there also is no Maryland case. The Maryland Court of Appeals, the highest court at the time, in the 60s and 70s, you have the Silver versus Goldberger, Sliver versus Goldberger, Becker and Bailey. Those cases are the ones that outline, that state what the legitimate business interest is that you can protect with a non-solicit or a non-compete. So to your point, there's not a case that says confidential information is not a legitimate interest, but there's also not a Maryland case that says that it is a legitimate interest that allows you to prohibit someone from soliciting customers.
Right, and what we've said, though, is that federal courts should not expand those public policy exceptions, right? So the public policy striking it down is like a public policy view. And absent some existence of that in Maryland, we're not to go expand it. And what you're asking us to do is to expand it in a place where Maryland has not yet done so. They may well do so, I don't know. But they haven't done it yet. They haven't said that you cannot have a non-compete that's based on confidential information.
Well, Your Honor, again, I would look at it differently, that you would be expanding Maryland law if you were to say that under Maryland law, protecting confidential information with a non-solicit is a legitimate business interest. No Maryland court has said that. You'd be expanding the law in Maryland on that issue.
Because you think the default rule is that you cannot enter a contract, not that the default rule is that you can enter a contract. I mean, maybe you're right about that. I've not seen Maryland take it that direction, right? I see Maryland have said you generally can enter a contract, that Maryland generally supports entering a contract, but there's this subset that is not permitted. And
That's
so that the
correct.
default is that you can enter a contract. And so we would be expanding the public policy exception to the freedom of contract in order to prohibit this type, when no court has ever prohibited this type of a provision.
I would look at it a little differently, Your Honor. I would say that there has been, the Maryland Court of Appeals has spoken on this issue and said that these types of agreements are only enforceable for this purpose, and that is to protect the goodwill created by the employee. And therefore, if you were to expand it and say, and with respect to anybody who has confidential information, you'd be expanding Maryland law on this issue, not creating an exception to the general concept that parties can enter into a contract. The Maryland court has spoken on this and has said these are the only, this is the only interest that can be protected by this type of covenant. Now, just briefly on this, the blue penciling issue, they argue, well, Judge Hollander also erred in declining to blue pencil, but as Judge Hollander correctly found, she would have had to have deleted more than 2/3 of the definition of covered customer. And those type of extensive modifications are not, first of all, they're certainly not required by Maryland law. And second of all, it was well within her discretion to make that determination that that type of extensive modification of the agreement for a billion-dollar company with one of the largest law firms that could have simply worded the provision correctly so that it would be enforceable under Maryland law and we wouldn't be here, her discretion in that regard should be respected. I would also point out that I think Judge Benjamin asked about where in the complaint did they allege a breach of the non-solicit. And again, there is nowhere in the complaint that they, or even in the amended complaint that they did. In the amended complaint that Judge Hollander did let them file after discovery was over and at the summary judgment stage, she applied the incorrect standard to allowing them to amend after entry of after the deadline had run in the scheduling order. She applied essentially a standard that was, she said it was that their lack of diligence was not so egregious as to justify denial of the leave to amend. But that's not the standard. Under Rule 16, as this court has said, and multiple other federal courts have said, under Rule 16, you have to show diligence. And here, the record demonstrates they didn't show diligence. They waited at least 3 months from the time that they had the information, and then even after they contacted us and said they wanted to amend again, and we said no, they waited another month. So Judge Hollander applied the wrong standard in allowing them to amend to even add the non-solicit claim, which was not part of their operative complaint at the time. Now, with respect to the non-disclosure provision, that provision is also unenforceable under Maryland law, but you don't need to get to that. There's no evidence in the record to create a question of fact as to whether Mr. Bero violated that provision. Even after this invasive forensic search protocol that scoured all of his devices, they were unable to present a shred of evidence that Mr. Bero misused any of their information. All they point to is that Mr. Bero sent the information to himself. That by itself is not a breach of the non-disclosure provision. First, the provision is entitled Covenant Not to Divulge Confidential Information. He didn't divulge information to anyone. Moreover, the provision states that an employee shall not use, disclose, or divulge any confidential information to any other person or entity. He didn't disclose it or divulge it to Jabot or anybody else. He sent it to himself. And no reasonable person could interpret other person to mean oneself. doing so would be contrary to the dictionary definition of what other means. There's also no evidence that Mr. Bero used any confidential information. They try to insinuate in their brief that with this BOB spreadsheet that he created after he left from information that he obtained on the internet or that he had in his memory, that somehow that was the use of confidential information of Aston Carter. However, if you look at the record, there's absolutely no evidence to support that insinuation. And so Judge Hollander correctly found that there was not sufficient evidence to go to a jury on that issue. But even if you were to find that there was a question of fact and Judge Hollander got it wrong on that issue with respect to the confidentiality provision, that provision is also unenforceable under Maryland law. Both this court and the Maryland Court of Appeals have held that under a Maryland law, a restrictive covenant and nondisclosure provision like this may apply to only certain categories of information. For example, as this court held in E.L. Conwell and Company in 1970, Maryland follows the general rule that restricted covenants may be applied only to those employees who provide unique services or to prevent the future misuse of trade secrets or lists of clients. So there's no evidence here that this information is a trade secret. They didn't even allege a trade secret claim.
Why
But
would
then,
list of clients and soliciting customers apply?
I'm sorry, Your Honor.
List of clients and soliciting customers.
Whether
You said
they're-
it doesn't apply.
the list of clients, that the confidentiality provision can only apply to trade secrets or lists of clients, and then there's some later cases that talk about routes. That if the confidentiality provision goes beyond those things, under Maryland law, it's unenforceable. Now,
But you agree it's not limited to trade secrets?
I agree, absolutely.
And help me understand, because I had understood the district court to suggest that it was limited to trade secrets.
I don't believe that's correct, Your Honor. The law.
Help me understand how I read her opinion to not do that? I mean, I didn't pull it up right this second, but why do you think it isn't so limited?
Well, because I think she references the Conwell case, and then I was going to talk about the Becker versus Bailey case, which is from the Maryland Court of Appeals, in which it favorably cites the Conwell case from this court. And in those cases, those cases say.
Wait, but you're saying she did that by referencing them? She doesn't seem to talk about it that way. I mean, I confess that I haven't read it this morning, but she doesn't seem to talk about it that way, right? Seems like to me the best reading of what she said is that, listen, this is just for trade secrets.
I'd have to look back myself, Your Honor. I can't say I've committed.
But you
to memory.
agree to the extent, if one read her opinion, hypothetically, as saying this can only apply to trade secrets, you agree that's not right. You might have a disagreement about how much more is included or not included, but it's certainly not just trade secrets.
I agree with that, Your Honor, but the end result is this provision is unenforceable under Maryland law because it goes beyond trade secrets, client lists, and routes, which is what Maryland law says is protectable by a confidentiality provision of this nature. So, again, the Maryland legislature, if they want to change that, we have a statute in Georgia that says, here's what confidential information that doesn't rise to the level of a trade secret is, and here's how you protect it. If Maryland wants to pass a statute like that, that's up to the legislature, not for this court to change the law in.
So you're reading this line from Becker that says those decisions demonstrate, and then it gives a list of things that can be protected, and it cites the cases. You think that's an exclusive list, right?
Yes.
Where it says, to prevent these things, and it cites the cases that match those? You think we should read that sentence from Becker to be an exclusive list?
If you read that in context with E.L. Conwell and then all of the subsequent decisions that interpret those decisions, yes.
Thank you, counsel.
Thank you.
Do you go?
Thank you, Your Honors. Just to follow up very quickly on the discussion that you just finished with my colleague on
Can
the...
you start with the A to I point, where it was
Yes.
raised below, and what, if any, record evidence there is that Aerotek or Aston dealt in the space that you've alleged?
Yes, Your Honor. So the complaint, fairly read, we think the complaint, which appears at pages 9 through 23 of the joint appendix, and the agreement itself, which was put before the district court, pages 355 to 364, among other places in the joint appendix, put this issue in front of the district
Well, I'm
court.
looking
which
at
was
it.
Can you
but
point
I-
us to anywhere, I mean, you just said, oh, you just got to read the whole complaint?
Your Honor, so the...
Is there
breach-
anywhere that you cite AII in the complaint?
Yeah, the complaint does not specifically cite.
And I'm looking at your summary judgment motion, brief below on the JA 321. And in here, JA 320 and 321, it's AI, and then you skip over to 18. I guess that was your second argument regarding divulging confidential information. There's nothing in here in your argument regarding AII 2. And that's on JA 320 and 321.
No, admittedly, Your Honors, the argument below was not focused on JIII. We think that provision was still nevertheless fairly in front of the district court because we alleged a breach of the non-solicitation clause and included the entire provision, and the district court should have read the provision in context. And that's the argument we're making at this point.
So the district court was supposed to go to the contract, even though you didn't raise it, and find AII, and then help me understand, what is the evidence that you, or allegations you put in, that Mr. Bero took action for the purpose of harming your Allegis,
Your Honor.
as opposed to the purpose of making money himself? What's
No,
the evidence of that?
There's no evidence that Mr. Bero, with the subjective intent to harm a company, made the solicitation. The way we think the agreement should be read is, and Your Honor, my time is up, if I may finish.
You can finish the sentence.
We think the agreement fairly read means that Mr. Bero, if he took action, that the natural consequence of, purposive of that action was to reduce the business with a covered company, with a covered client, then that was a breach.
Thank you, counsel.
Thank you, Your Honor.
We very much appreciate y'all being with us. As hopefully you know by now, we come down and greet counsel, and we'll do that and proceed to the next case, which I suspect will be a similar story. It is 24-1372 Aerotek versus Nosky, but we'll come down and greet counsel now. Be seated. Mr. McDonald, we're happy to hear from you again.
May it please the court. As in the prior case, we're here on appeal because the district court misapplied the law to 3 provisions in an employment contract. 2 of those provisions were explicit, and 1 was implicit, implied by Maryland law. The first provision was a return clause, which required the appellee, Mr. Nosky, a former employee of Aston Carter, required him to return any company record in any form at the end of his employment. The second provision was a non-disclosure clause, which forbade Mr. Nosky from using, disclosing, or otherwise divulging the company's confidential information. And the third provision, this implied provision, was a duty of loyalty under Maryland law, which is applied in every case. I would like to begin with the return clause in this case. Again, that clause forbade Mr. Nosky required Mr. Nosky to return all company records in any
Is
form.
there any dispute, do you all dispute that Mr. Nosky deleted all of the emails. Is there any dispute there?
There is no dispute about that, Your Honor. Mr. Nosky did delete those emails 10 days after taking them on his first day of employment with his new employer. The record shows after speaking with counsel, he decided it was no longer a good idea to have those records and deleted them. Nevertheless, we believe the record shows clearly that Mr. Nosky violated the return clause by never returning those records to Aerotek after his employment ended. The district court in this case concluded that that provision didn't apply to electronic records despite the clear language of the agreement. The agreement says that Mr. Nosky was to return records in any form. And then in the very next sentence of the paragraph defines company records to include electronic records such as email. The district court
So
never...
it would be your position that he would need to, I guess, download the emails and then on a drive and then return the drive to you? Is that, I mean, how's he gonna return emails, which I'm assuming that you already have on your hard drive, right?
Yes, Your Honor.
I mean, Aston, yes.
Yes, Your Honor. Aerotek in this case did still have copies of the records. And
Because the point being that the email is sent from your system, which means you have it, and it's received by his system, which means he has it. To maybe the same question that Judge Benjamin, how is it that you envision that the email is returned? I mean, because if he sends it back to you, well, now we just all have 2 copies of the same email, right? Like, what does it mean to return an email, something that you already have?
yes, Your Honor. So the two points about that question. The first question is just from a mechanical standpoint, the way Judge Benjamin suggested would be one way to return the record. Another way would be to send the
Yeah,
email
but then
back
he still got it, right? That hadn't actually returned it at all, right? So, like, I can copy an email off of my system and I can hand it back to you, or I can attach it to another email and send it back to you. But now I'm just creating more copies of it.
That is absolutely true, Your Honor. But the existence of the copy does not prevent a return, either logically or linguistically. What we're concerned about when we talk about a return is the actual transmission of the information back to the company. And that serves both
But it's information you already have.
In this case, Your Honor, that is absolutely true. We still have the record, but that will not be invariably true. Imagine a scenario in which the employee
But
destroys...
we're talking about this case and what happened in this case. We're not talking about the hypothetical case.
Yes, that's absolutely right, Your Honor. But the provision is not just written for this case. It is written for every case. I mean, the
But
obligation
you're
to
asking
return
the
still
court
exists.
to enforce it in this case, based on the facts in this case.
Yes,
Where
Your-
there was, where the company has the property, it never actually changed hands. Because the company still has the property.
Yes, Your Honor. Yes, Your Honor. In this case, the company did have the records. But the return provision nevertheless applied, even if the company still had its own copy of the records. Imagine that if Mr. Nosky, rather than taking a digital copy, had photocopied it and walked out the door with a physical copy. The obligation still nevertheless would have attached for him to return those records. Those records would still belong to the company. And the return provision in this case actually serves a functional purpose separate and apart from recovering the information, even if the company has it. It allows the company to take an inventory of information that has gotten outside its exclusive control, which allows it to then exercise its rights under the subsequent clause, which is the retention clause, or the destruction clause, however you want to think about it. That clause requires Mr. Nosky to retain whatever copies of records he has in his own possession until authorized by the company to destroy them. The company can't exercise its rights under that clause unless it knows what Mr. Nosky has. And the only way it knows what Mr. Nosky has is if he has to do something under the return provision.
Email it back. So now and this is a perpetual loop, because once he sends it to you the first time, well, now he's got another copy of it, so he's got to send that one to you. I mean, this seems like an absurdity argument to me, right? That you have set up or sort of dreamed up in order to become a prevailing party, some like crazy theory that requires the return of emails by a like infinite loop, right? Is that, I mean, that's what you want us to sort of say? I mean,
No.
that's really the argument that you're making?
No, Your Honor, we don't think this creates an infinite loop. The way this should work in practice is
But
that...
once he sends it, he now has another copy.
Yes, Your Honor, at which point the
He
company...
needs to send it again.
Well, at this point... Excuse me, Your Honor.
That's what the loop is, right?
Your Honor, we
Because it
don't...
doesn't say you have to return it in a particular way. right? He just says, your theory is he has to return it, so he emails it. Well, now he's created another record. And so it's a literal infinite loop.
At that point, Your Honor, we don't think this creates a loop for this reason. Once Mr. Nosky sends the email back or hands a copy back or however it is that he returns it to the company, and there are multiple ways that it's possible to do this, the company would then know which records he has in his possession and could instruct him to destroy them. And at that point, the loop that Your Honor has posited ends.
So they can excuse his performance, unilaterally excuse his performance under this paragraph 7.
No, Your Honor, we don't
By
think,
saying, now you have another copy of it, return it, but you don't have to do that anymore, you can just delete it. But it's just like a unilateral, story. You just get to tell them when they can stop returning your documents.
no, Your Honor, we think just the functional way this should work is that once the company has been able to take an inventory of those records, it can exercise its rights under the second clause. We don't think that creates any kind of unilateral excuse of obligations, Your
So
Honor.
help
unless
me
I'm
understand why, so totally get your point, right? So because this is irrational, you have one functional way to read it, right? Which I think is contrary to your understanding, but I get that there's got to be some end to the loop. You have a functional argument. Why shouldn't we adopt the other rational, functional argument that return of an email is like a conceptual impossibility? There is no such thing. And so, yes, this provision applies to all sorts of records. And if he had a photocopy, he might have to, return that. But it is nonsensical to refer to the return of an email.
Two reasons, Your Honor. The first reason is that linguistically, the ordinary definition of return is simply to restore to the original owner. And so we think that ordinary definition, which is how you read contracts under Maryland law, would encompass returning an electronic record in one of these fashions. The second reason is a practical reason. If, in fact, it is true that return provisions are unenforceable to electronic records, the practical implications would be that an employee could download whatever he wanted, leave, and have no obligation to return under any return provision, not just this one, but any return provision in any contract, which would mean that no matter how clearly the parties had written an agreement, which we think this one is exceedingly clear, that they intended the return provision to apply to electronic records, it would be unenforceable because it would be a quote-unquote logical impossibility to return an electronic record. It would wipe out every return provision in any agreement across the
This
country.
is what happened when you make crazy arguments, you get crazy rulings, right? Because once you sort of take a provision and try to use it to a conceptual impossibility, you force us to explain why your argument means that all of these provisions don't apply,
Your Honor, we wouldn't.
right? I mean, that's what happens when you make these ridiculous arguments, right? Like bad facts make bad law, but that's your doing, right? Like you've sort of brought this argument that they should return an email in creating some sort of an infinite loop.
No, Your Honor, I think this case can be resolved by just a straightforward application of what the parties clearly intended from the language of the agreement, was that this return clause would apply to electronic records, so it has to be read to mean something. And in this case, what that would mean is that Mr. Nosky had to send the record back. He either had to forward it back the same way he took it, or that he had to download it to a physical drive and hand it back.
And once he forwarded it back, he now has created another copy that he's got to then forward back. I mean, that's the problem with it, right? That once he forwards it back, he now has created another electronic record because he's got another copy of the same email. Well, now he's got to forward that one back, right? Because your claim is that that is a record that he has to return.
Yes, Your Honor. I understand that point. I think the way to resolve that is simply to apply the company's rights under the return, or excuse me, the deletion or retention provision, however you want to phrase it, that the company would then at that point exercise its rights to instruct him to destroy what he had. The main point of this provision, as applied to electronic records, is so that the company can exercise control over records that have escaped its control and ensure that no further records exist.
But there's no dispute that he deleted them 10 days later, right?
He did delete them 10 days later, Your Honor, but he did not return them at any point.
Assuming we affirm the district court on the other claims, does your duty of loyalty claim go forward?
Yes, Your Honor. The duty of loyalty claim is independent of the return provision or the confidentiality provision. I'll turn to that now. Under Maryland law, every employment contract carries an implied.
Why are we applying Maryland law? Wasn't he employed in New Jersey, isn't that right?
Your Honor, Maryland law applies the internal affairs doctrine to duty of loyalty claims, as the district court found and cited the Zenimax case, which is the only Maryland case cited by either party, and the only case that we're aware of applying this, the choice of law rules of Maryland to duty of loyalty cases. And under
Right,
that.
but my understanding is that under Maryland law, the internal affairs doctrine only applies to high-level employees, shareholders, directors, officers, not line employees like Mr. Nosky. Is that right?
I don't believe that's right, Your Honor. I think that as read by the district court and as read and stated in Zenimax, I think that applies to, I would have to look at Zenimax again, Your Honor, to be frank with you. I don't think it's that limited, but we can certainly follow up on that point. But nevertheless, it is the most on-point case applying Maryland law to a duty of loyalty claim as far
But
as
how
the
would,
choice.
if we found that he did not violate these provisions of the contract that of returning and preserving and disclosing, then where is the violation of the duty of loyalty?
Yes, Your Honor. So Mr. Nosky violated his duty of loyalty the moment he stole company records and walked out the door or sent them to himself, contrary to Aerotek's interest and contrary to his agreement. And the reason is this: the scope of the duty of loyalty under Maryland law is not, as the district court framed it, to merely refrain from retaining company property for a particular period of time. It's an essential agency principle, which is to always act within the principle, the employer's interest, within the scope of that agency, that employment. And Mr. Nosky.
So you're suggesting outside of the contract, any employee that forwards to him or herself an email from the employer to their personal email is then in violation of the duty of loyalty?
If,
It seems to me many employees do that. They send things to their home email, the work email's not working, they want to work on something at home, people are working remotely. Is that then a violation of the duty of loyalty without more?
I think this is an intentionally fact-based question, and what we would have to look at is whether that action somehow contradicted the interest of the employer by forwarding that email. In this case, it did, because Aerotek had taken pains to protect this information. In this industry, the type of information that Mr. Nosky took in this case was intensely competitively sensitive, and it was.
But under Maryland law, what is your economic harm? There's no, what is the harm here that you have to show economic harm under this duty of loyalty? I think it's a Maryland metal case or something like that. But what's your economic harm?
So the Metzler case, Your Honor, suggests that there needs to be harm, but it's not necessarily economic or financial harm. The harm in this case was that Aerotek had taken multiple steps to protect this information from further disclosure, and merely by taking it outside the company's protection, outside of its systems, Mr. Nosky then exposed it to further risk. He undermined all of the steps the company had taken to protect this information from potential disclosure.
We're here on summary judgment. Is there evidence of this in the record? That he exposed the company to risk by sending the email to his home email and then subsequently deleting it 10 days later?
There was deposition testimony suggesting that once this information is outside the company's control, it has no way to track, let alone prevent further disclosure. And so by taking it outside the company's control.
Right, but as Judge Benjamin pointed out, one of the elements under Maryland law, if we are applying Maryland law, is damages.
It is harm, Your Honor. I don't think any of the cases suggest that it must be financial harm, that the company must have lost money as a result of the harm.
And what's the harm here?
And the harm here, Your Honor, is that the company lost control of its records.
So we're back to my original question about then any forwarding of an email by an employee to him or herself to the home email would then be I think what you're saying is, as a matter of law, would be a violation of the duty of loyalty.
I think what we're saying, Your Honor, is that this is a fact-based.
Do you agree with that question? Because it seems like you're saying yes.
No.
Because they've lost control, right? It's now to the whims of, Google's security efforts, which are, I assume you think not good enough. But like, do you agree or disagree with the question? You just didn't answer a question.
Yes, Your Honor, let me be specific. I do not believe in every case it would be a violation of the duty of loyalty to forward anything from a company
So
account to a
what
person.
facts in the record suggest in this case it is?
That the information was intensely competitively sensitive, which the company had taken multiple steps to protect, including
So it
contract.
turns on the nature of the information. So no matter what his intentions were or anything else, if the information is sensitive, then any forwarding of that information violates the duty of loyalty.
If it puts the company's interest at risk and acts against the
You said it does, because it's out of their control now, right? So it's out of their control. He believed subjectively that hypothetically, that he needed this information to do his job because your computer system didn't work well, hypothetically. And your answer is, it's sensitive information, and if he sent it out there, he has put it at risk. And so now he's violated the duty of loyalty, no matter what his subjective intent was, right? That it solely turns on the nature of the information.
So on the facts here, Your Honor, there's no question Mr. Nosky took this to continue working on it for at Aerotek's interest. He took it on the last day, rushing out the door. He wasn't intending, there's no
But
suggestion.
when you answered her question, at no point did you look at the subjective intent, right? So my point is, the subjective intent doesn't matter. You just said, this is really sensitive, right? We can't possibly let this get out. And so it just turns on the nature of information. So no matter what, in Judge Berner's question, even if he's doing it, with the purest of heart, it would make no difference because he's put your information at risk. And that's a violation of the duty of loyalty, as you've suggested to.
No, Your Honor, the nature of the inquiry under Maryland law is whether the employee is acting in the employer's interest. And so in some facts, the facts Your Honor is positing, which are not the facts in this case, but the facts Your Honor is positing, an employee takes the information because he's trying to forward the employer's interest, that would not necessarily be a violation of the duty. In this case, there's no question, my time is up, Your Honor.
I want to understand why this is a violation of the duty.
Please.
Why in this case is it a violation of the duty?
Because Mr. Nosky took the information for his own purposes, contrary to Aerotek's purposes. He took what he considered to be quote-unquote useful. And there's no question that it wouldn't be useful for Aerotek because that was the last day of his employment with Aerotek. Now, he denies it was useful for his new employer, JoBot, which leaves only one party, Mr. Nosky himself. Thank you, Your Honors.
Thank you, counsel. Mr. Khan, we're happy to hear from you.
Thank you, and good morning, Your Honors, and may it please the Court. My name is Jeremy Kahn, and together with my partner, Ben Fink, I represent the appellee, Mr. Ken Nosky. The Court should affirm the District Court's grant of summary judgment to Nosky and the denial of Aerotek's motion for summary judgment. There is no genuine dispute of fact that Mr. Nosky emailed himself a mix of personal and Aerotek files that were on his work-issued laptop. There's no genuine dispute of fact that Mr. Nosky then returned the laptop that contained those files and never deleted them from that laptop that contained the files that he returned to Aerotek. There's no genuine dispute of fact that Mr. Nosky never used the Aerotek files or disclosed them to anyone in the 10 days that he had them. And there's no dispute of fact that Mr. Nosky there's no dispute of fact they deleted them. There's also no dispute of fact that Aerotek suffered no damages from any of Mr. Nosky's conduct. And that's stated several times in the record, but probably most cleanly in Aerotek's, one of their summary judgment briefs where they respond to our cross motion at JA 469. They say they don't contest our arguments, at least on partial summary judgment as to damages. They don't have any economic harm or any harm at all from anything that Mr. Nosky did. There's three claims that are at issue in this appeal: a breach of a nondisclosure provision, breach of a return of records provision, and breach of the duty of loyalty. Unless the court has a different preference, I'll start with the nondisclosure provision. On summary judgment, Aerotek tried to argue a claim that it never pled, this disclosure to Google theory. In its complaint, which it amended twice and still never added this theory, the last amendment was actually several months after a forensic search protocol confirmed that Mr. Nosky never forwarded any of this information to Jobot or anyone else. They still never changed this part of their complaint. They never added anything about Google. In count 1, entitled Breach of Agreement, they allege Nosky has breached paragraphs 6 and 7 of the agreement in that he has, upon information and belief, used or disclosed Aerotek's confidential information for his and Jobot's benefit and failed to return Aerotek's property upon his termination. That, as masters of their complaint, that is how they framed their breach of contract provision. And we catalog in our brief multiple other instances in the general allegations where the entire claim is based on this false allegation of a disclosure to Jobot or use with the employment of Jobot.
I think they're saying because he had the intent when he downloaded everything on the last day that would be the breach of the contract or breach of fiduciary duty claim is because of his intent at the time.
I understood Mr. McDonald to say that with respect to the breach of fiduciary duty claim. On the non-disclosure claim, the non-disclosure provision prohibits only use or disclosure, not retention, not sending something to yourself. They easily could have put that in the agreement, but it's not there. And in some of the cases that they cite, there are non-retention provisions. That's not in this agreement that they drafted. As to the duty of loyalty with regard to Mr. Nosky's intent, the record is very clear from his deposition that he did this in the last 5 minutes before he had to return the laptop. He had a bunch of personal things on the laptop. When he said he wanted to send what was useful, it was useful or valuable to him, not useful or valuable to use against Aerotek or for Jobot or for any business purpose. He testified that he had no business purpose in doing this. He just, and you can tell by the titles of the subject lines of the emails he sent himself, he was just trying to grab everything that he had that might have been important to him because he was about to give back this laptop. He didn't have his own personal laptop. This was the only laptop he used. So he sent it to himself, but he had no purpose in using it to compete or for any other business purpose. There's nothing to dispute that regarding his purpose. And actually, one of the bases to affirm as to the duty of loyalty is that he had no business purpose. He had no...
There were dog videos, isn't that right?
There were dog videos. I think there were some of his tax returns. There was a mass card. There were pictures of him and his coworkers. The overwhelming majority of what he sent himself was personal. There were I think, several spreadsheets. I think it was 45 spreadsheets of this massive amount of personal information that he sent himself. But he never used it, and he never had the intent to use it. He said it would not have been useful for the job that he was going to at Jobot. So it was included in this massive emails that he did in 5 minutes in a very haphazard way. But as he testified, it was random, and he did not have a business purpose in doing it. And again, he didn't do anything to harm Aerotek. Aerotek did not suffer any damages. And with respect to the duty of loyalty, unlike a breach of contract...
Do you think Maryland law applies?
I believe that Maryland law applies...
To this claim, I mean, I should have asked the question more specifically. With respect to the breach of the duty of loyalty claim, do you think that Maryland law applies?
No, Your Honor. It applies only to the breach of contract claim because the contract itself says that it's governed by Maryland law. But for a tort, Maryland follows the lex loci delicti rule, which states that the last act to complete the tort is where where that occurred is the law that's applied.
After Plank, do we? I mean, it seemed maybe, but in some senses, the breach of loyalty claims in Maryland seem to sound in contract, not tort, after Plank?
In all the cases that I've seen of Maryland law or this court construing any fiduciary duty claim, including a duty of loyalty claim or any other fiduciary duty claim, it's described as a tort.
Do you think that remains true after Plank?
Yes, Your Honor, it does. It's separate from the contract, and actually the duty of loyalty has been held to apply even if there's no breach of contract. It's separate and independent from the contract. So it arises when there's an employment relationship, for sure. There's a contract that's there, but the duty of loyalty is separate. It's from the fiduciary duties that arise independently based on the employment relationship or the agency relationship. It's not based on the contract itself.
Would it make a difference in terms of outcome if we were to find that there was error in the application of state law?
It would not in this case, Your Honor, because while the district court did err in the choice of law, the district court did not err in its application of Maryland law. So if Maryland law does apply, the district court correctly held that the duty of loyalty was not breached under the Maryland law, because every single case, federal or state, that describes the duty of loyalty or a breach of duty of loyalty states
Can I
that.
ask her what I thought maybe was her question? If you're right about the choice of law, does that require that we remand to the district court? Or can we affirm because the same principles apply under the law that you think does apply?
If the court holds that there's the same outcome under Maryland law or New Jersey law.
Well, yeah, no, but I'm asking you, so under New Jersey law,
Yes.
do you think that that choice of law matters? Does it change the analysis in some way?
In some respects, it does. New Jersey has a multi-factor test. We argue each of those factors in the court below. Aerotek chose not to respond at all to our arguments regarding New Jersey law, and they don't argue anything about New Jersey law in their briefs here. So they've waived anything under New Jersey law. Where New Jersey law and Maryland law are the same is that both require damages to complete the tort of a breach of duty of loyalty. We cited cases both from New Jersey and Maryland that there has to be damages, and they conceded that there are no damages in this case. And that kind of dovetails with actually the standard under Maryland law that there has to be.
What's your response to his argument that their harm was the loss of control, that, Gmail might get hacked or, that it's now at risk in some peculiar way, and that risk of harm, even though it didn't come about, is some form of damage or harm?
That's extremely speculative and hypothetical. If Mr. Nosky still had the information, then they wouldn't need actual harm. They could have a risk of imminent harm and seek an injunction. But Mr. Nosky deleted all this well before the litigation was commenced, so they didn't have that argument, they didn't have that basis for the claim. So you don't have to wait to be harmed to sue for the breach of duty of loyalty. If you have imminent harm, a reasonable anticipation of imminent harm, you can seek an injunction based on it. But there's still a harm analysis there, and you're trying to prevent harm from occurring. Here, there was no harm. The hypothetical that they've come up with did not occur. Everything was deleted 10 days later. It was never used. It was never disclosed. Nothing ever happened with it. Aerotek has never pointed to a single dollar of loss, and it conceded in its briefs that it has no compensatory damages for the breach of contract or for the tort claims. Assuming if Maryland law does apply, the standard is that there has to be active competition or misuse of confidential information. And that didn't occur here. If Mr. Nosky did something with the confidential information, if he used it to help Jabot, he used it for something he didn't have in his memory, that could be a breach of the duty of loyalty, but that's not this case. Merely sending something to yourself and temporarily possessing it for 10 days is not a breach of duty of loyalty, and Aerotek has never cited a case, federal or state, to suggest otherwise. In every single case they cite, it talks about misuse of confidential information, and in every single case, the employee, if the claim was upheld, did something much more egregious than merely send something to himself and possess it for 10 days. And in Metzner, as well as multiple other cases that cite Metzner, the standard is not just harm. There has to be substantial harm that hinders the employer's business operations. And in the cases that they cite where a duty of loyalty claim is upheld, that's what's alleged, that's what occurs. There's either some mass resignation of employees.
I just want to give you the chance to address it. I know your colleague did. But what's your position on why your client didn't breach the return provision?
Your Honor, I think Your Honor hit the nail on the head that there would be this infinite loop. You cannot, Maryland law does not require an impossibility. We've cited cases that say that under Maryland law, if a contract requires an impossibility, it's unenforceable. The contract can't require you to do something that's impossible. It is impossible to return an email. What is possible is they could have drafted a better contract. They could have said you're not allowed to retain any information. They could have said if you have you can't send yourself anything to your personal email. They could have said if you have anything, you have to notify us, and we have to agree to an inspection or a deletion protocol. These are common provisions in lots of employment agreements, including in some of the cases that they cite that are absent from this agreement. In this agreement, they say return records, all records and all copies. So their proposed solution doesn't even work under the text of their own agreement, because when you're if you're sending it back, you're not really sending it back. You're creating a new copy and sending that copy and still retaining your copy. What Mr. Nosky did in compliance with the agreement is the original files were always on the work-issued laptop. He didn't delete anything. There's a separate deletion provision that they also allege that he breached in the district court below. District court found against him. They haven't briefed that issue or challenged the district court's findings on that claim, but the district court interpreted the deletion provision correctly in that it says that you can't delete anything during your employment or upon termination. And that's the concern that I think Mr. McDonald was trying to get at, which this provision takes care of. They don't want an employee to delete a bunch of things that are important to the company, so the company no longer has it. If Mr. Nosky had wiped his laptop before he returned it, he would have violated that deletion provision. But there's no retention provision or non-retention provision at all in the agreement. It talks about unauthorized deletion during or upon termination, or return of records upon termination. And it is impossible, as Your Honor noted, to return an email. You just can't do it. And in this case, there are other provisions. There's a confidentiality provision about no use or disclosure of confidential information. Mr. Nosky complied with that. He didn't use it. He didn't disclose it to anybody. So there are still other protections, but he did not violate this specific provision. And the only reason that they're fighting so hard on this, what Your Honor called absurdity argument, is because they want to get a nominal damages award so they can throw a prevailing party attorney's fees provision on him for this, what they would call a technical breach, what we say is not even a breach at all, because it's an impossibility to return an email. And even taking it another step forward, if you apply their logic to hard copies, had Mr. Nosky taken an actual piece of paper from Aerotek, and they asked him to return it, and he Xeroxed it and provided them the Xerox and kept the original, under their argument, that would be acceptable. I don't think that that actually would be acceptable to Aerotek. They want all the copies. The agreement says return all records and all copies. That's impossible to do with an email. It's possible to do with a hard copy, but it's not possible to do with an email. But if Your Honors are going to apply their logic, it would have to apply equally in both circumstances, and making a Xerox of a hard copy would somehow be complying with the agreement, which it wouldn't. I want to also address the issue whether they even pled this disclosure to Google claim. The complaint does not mention Google at all. This came up for the first time at summary judgment. They asked a few questions at a deposition, but they never gave us notice of this disclosure to Google theory. And they amended the complaint twice and still never gave us notice of this disclosure to Google theory. The district court correctly held that this was not even a pled claim. And on the pled claim, the disclosure to Jabot theory, they had no evidence of it, and they haven't raised that one on appeal. So one they haven't raised on appeal and they've waived, and that's the one that they actually pled. The one that they didn't plead, the court correctly found was not pled and should not have even been considered. Even if the court is going to consider that claim, however, they did not provide any evidence of a disclosure to Google. Just pleading, their only argument in their brief, in their opening brief, is that they pled this claim, which they didn't. But even assuming they're right about that, pleading a claim does not get you a reversal of summary judgment. We pointed to an absence of evidence. We did the best we could, even though we didn't take discovery from Google, to oppose this claim. And we showed that there was no evidence of any disclosure to Google, that Google could access the files, that anyone at Google did access the files. And they don't have any evidence that they cite in the record or that they provided at summary judgment to support that claim. All they argue here is that they pled it. Merely pleading is not enough. What they wanted the court to hold is essentially a per se rule, is that anytime you send something to a Gmail account, that is automatically also a disclosure to Google. That does not gel with the common sense, the common meaning of disclosure, and there's no evidence of it. They cite some, the court below, they cited some terms of service. Those terms of service don't even apply because they cited 2022 terms. This all occurred in 2021. Mr. Nosky created his Gmail account many years ago when he was a minor. The version that they cited, assuming it's the same as when he created his account, says it doesn't even apply when you're a minor, and nothing in the actual terms that they provided, which don't even apply, say that Google can access email attachments such as this. They cited a reference to a license over something called your content, which is a defined term that had a link. They never provided the link or the definition of what your content is. So there were multiple reasons in the court below why we argued that even had they pled this claim, there's no evidence to support it, and we were still entitled to summary judgment. They don't really address any of those in their brief. They cite in their reply brief, which improperly, because it should have been in the opening brief, a new Google document that says nothing at all about the ability to access any information.
Anything else you need to add?
No, Your Honor, if the court has no further questions, we would rely on our brief and respectfully request that the court affirm the district court on all claims.
Thank you, counsel.
Thank you.
Mr. McDonald, you got a few minutes.
Thank you, Your Honors. I'll briefly start with the question about the application of Maryland law to the duty of loyalty claim. Mr. Nosky cites the Lex Loci doctrine. The Lex Loci doctrine is a tort doctrine, whereas under Maryland law, the nature of the claim of a duty of loyalty implied in an employment contract is contract. One case to look at for this point is the Faust case. That case involved a claim that, a dispute about whether an employee was entitled to attorney's fees.
Why are we looking at Maryland law to determine whether Maryland law applies to a tort when the tort took place? Nothing is alleged to have taken place in the state of Maryland.
The point I'm trying to make, Your Honor, is that under Maryland law, the nature of this claim.
I understand that that's under Maryland law, but Mr. Nosky worked in New Jersey and never worked in Maryland. We're applying Maryland law because that was a choice of law in the contract, but the question I asked you was whether your tort claim survives if we were to rule against you on the breach of contract claims. And so on the tort claim, I'm not even sure, in any event, on the tort claim, wouldn't we apply the law in the state where the tort took place?
Your Honor, the reason I'm citing Maryland law is that the nature of the claim itself is contractual. So it is of the same nature as the other contract claims in this case. It is a separate contract violation, which is why we look to Maryland law. And it is a contract violation because it is an implied term within the contract under Maryland law. The basis of the claim is not a tort, it is a contract claim. So the very nature of the claim is contractual, is why we're looking to Maryland law. Mr. Nosky also argues that the nature of this claim also requires some kind of misuse of the information to be actionable. That's not the case. In fact, we cite a Maryland case in our briefing, the McDonald case, which involved an employee who only tried to steal employee or employer information, was unsuccessful, and nevertheless the Maryland court determined that that was a violation of the duty of loyalty, which shows that there is no necessary element of quote-unquote misuse. Misuse is referred to in some of the cases, but it is not a necessary corollary of the claim.
Thank you, counsel. We certainly appreciate both sides on both of these cases. Having come down and greet you once, we are not going to return and do it again, but accept our great appreciation for your arguments.
Thank you.
We're happy to move to our third case, which is 24-4032, United States versus Victor Kelman. Just let everybody get situated. Mr. Bryant. Mr. Bryant, we're happy to hear from you. Thank you.
Thank you. Good morning, Your Honors, and may it please the court, Patrick Bryant on behalf of Victor Castro-Alemán, the appellant in this case. This case presents a narrow issue with broad implications, In the context of a collateral challenge to a removal order, when the government asserts that the defendant has waived his right to appeal the order, the burden should be on the government to prove that assertion. That allocation of the burden comports with general waiver principles, is not inconsistent with the statute, and makes good sense for policy reasons. First, I'd like to turn to basic waiver principles. The basic principle is that the party asserting a waiver has the burden to prove it. In this case, if the appellant, Mr. Castro-Alemán, had simply said, I am excused from exhausting my administrative remedies because I was denied the right to appeal, and the government had said nothing, if it had just been silent at that point, then the court would move on to the additional steps, which suggests that it's the government's burden to overcome that statement from the party, the non-citizen, saying that he was denied the right to appeal, because it's the government coming forward.
Well, but you agree the statute assigns him the burden, right? The statute under D, it assigns the defendant the burden, the alien the burden.
The ultimate burden of proving that the removal order was invalid. Now,
No, each of the three, D1, D2, and D3,
that's correct.
right? That he is assigned that burden with respect to each of those subparts.
Yes.
And so you start by saying, well, if he just said, I was denied my right to appeal, that somehow that would satisfy, I mean, he couldn't just say that and satisfy the burden, right? Like, that's the conclusion that wouldn't get him anywhere, right? He has to provide some evidence, not the conclusion.
Well, he would have to put it at issue, yes. There would be,
Not put it at issue, it's his burden to prove it, right? So he would have to put some evidence in. We can talk about what that might be, but he's got to put some evidence in on D1, D2, and D3.
that's correct, and he did so here, but then it would be the government, if the government doesn't say anything, then,
Then he will have met his burden, and he would prevail.
right, and so for the government then has to flip it, has to overcome it. And so that's why,
That's not normally how we think about burdens, right? Don't we normally think that, in a typical criminal case, right, the government bears the burden to prove knowledge, right? They put knowledge evidence in. If the defendant wants to counter that, it doesn't become their burden, right? They can just counter that evidence, and they can try to defeat it. But we think of like affirmative defenses that defeat the element of the offense, doesn't change the burden at all, right? That's just an attack on the evidence.
not the ultimate burden, but in the case of an affirmative defense, the defendant would have a burden of establishing the affirmative defense.
Only if the affirmative defense is independent of the element alleged, right? So if what the affirmative defense is to show that your client didn't have knowledge, right, then there's no burden. That's just attacking an element of the offense, right? If you want to allege, duress, right, that's a different affirmative defense. But this isn't an affirmative defense in that way, right? This is simply, you have the burden to prove that it was unavailable, and you could put on evidence that it was unavailable, and the government can respond to that by saying, no, it was available. I guess I don't understand why that is a distinct idea.
Well, I think it would work the same way as, for example, a discrimination claim or a Batson claim or the Bail Reform Act,
So
which
but
are
take a Batson claim as an example, right? So Batson, the court said repeatedly that the burden always remains on the defendant to prove the discrimination. There's a burden of production flip, right? So the second element in Batson has a burden of production, but Puckett tells us, like, it just has to be a facially neutral reason. There's no burden to prove the facially neutral reason, right? It's just a burden of production. The same thing in discrimination cases, McDonnell Douglas, right? The legitimate reason is just a burden of production. The actual burden remains with the criminal defendant in Batson and the civil plaintiff in the discrimination cases.
Well, perhaps it's more of a theoretical difference between a burden of production and a burden of proof. I think in the Batson context, where the government would have to come forward with a race-neutral justification, they have to establish that that is a race-neutral justification.
No,
They-
Puckett tells us that's exactly wrong, right? The Supreme Court has exactly rejected that argument, right? That what it says is the government must put forward a facially neutral reason, and then the burden remains with the defendant to prove that the reason for the strike was race or gender or whatever it might be.
Well, but if the government, for example, says, I struck him because of his race, that's not a race-neutral reason. And so that would be a situation where the government has to establish something, has to say something, meet some standard.
It has a burden of production, right? They have to give some evidence, right, that there was a race-neutral reason. That's correct.
Well,
Could we assume, for the sake of this conversation right now, that we disagree with you and believe that your client had the burden? Then can your client still prevail?
yes, Your Honor. I would like to, I do believe that the district court was mistaken in the factual finding that we did not carry the burden because the record here simply does not show a valid, voluntary, intelligent, knowing waiver of appellate rights. There's ambiguity and confusion throughout the record, but I would certainly point the court directly to JA 37 and during the removal hearing where the immigration judge says, do you want to accept this as a final order or appeal it to a higher court? And Mr. Castro-Almond said no.
But so help me understand here, except for a minute that I agree, there's some ambiguity in that, and that one could read that in a variety of ways. Why would we think that the district court committed clear error in reading it the way that it did, which seems like the better way of reasoning, not like we're totally required? I could imagine a district court reading it a different way and us being on review and saying that's not clearly erroneous either. But why would we read what, as you described, sort of is maybe ambiguous, or at least there's an ambiguous reading of it, and find clear error by the district court?
I think because there's such clear ambiguity and deep confusion all the way through this, and the context does not support that reading to a degree that the court can have any confidence or certainty in the district court's factual finding, reading this.
But if we have no confidence or certainty, right, the whole point of clear error is when we lack certainty, right, that means, right, we sort of have to have certainty the other way in order to find that the district court was clearly erroneous in its fact-finding, that, you know, what was said here was understood given the context.
I don't believe the clear error standard is quite that high. I don't think it requires absolute certitude on the other side.
It doesn't. You just used the word certainty, right? I was using your word,
Well,
right? But like, your point is, we can't have certainty that the district court was right. That's maybe not quite opposite of the standard, but that's basically opposite of the standard, right? Because we got a clear error, you know, maybe the district court like could have reached either result here if it was truly ambiguous, but
I don't think we're in equipoise, Your Honor, and I think, I don't have the quote in front of me, but I believe the standard language for clear error review is a firm conviction that a mistake has been made. And I think that's what we have here, that there's so much undermining that finding, that and this is such a small thread to go on that it's not really in equipoise. And then we also have the unrecorded final question that's not in the transcript. The government didn't even mention it in its brief, unfortunately, that we don't know what was left at the end of the hearing, what his final question was. And
problem is that hurts on the burden, right? Because your client presumably could have put in evidence as to what that question was or offered some allegation there, but there's not much we can, if we're right, and I accept that you have an argument that you don't bear the burden, but if you bear the burden, what do we do with a unknown? And how does that help you meet your burden?
well, I think it further undermines any sort of contextual argument that this was all crystal clear and that he understood what was going on and what he was waiving. We have this gaping hole, and we can't look at that and say, oh, well, obviously he understood what he was waiving and what this process, what appellate rights were available, when it's just such a thin reed for the court to hang its hat on. It can't support the finding that it made. And again, when we also pair up the first removal hearing, where Mr. Castor-Alamán was so confused about what he could do to raise an asylum claim, and the immigration judge seemed to give him some misadvice or not disabuse him of confusion there. It's just replete throughout this record that he doesn't really know what's going on. He's uneducated, uncounseled, and the government has a lawyer there that could have cleared all this up and didn't. And so there's just not enough in this record to support that finding. We think this is a case where the burden of proof, the allocation of the burden of proof matters, because if the burden were on the government to prove the opposite, to prove that this is a clear, intelligent, knowing, valid waiver, that it could not meet that burden. That's why we've urged the court to give us a clear holding one way or the other, and either affirm or remand on that basis, because this case really rises or falls on the placement. But with the time I have remaining, I do want to point out one thing in case the court would like to question the government about it. The government has argued that the Palomar-Santiago decision from the Supreme Court completely forecloses our argument here. We've explained in a reply brief why we don't think that's the case, but you don't have to take my word for it. This court has already said so in a case called Herrera-Pagoda, which unfortunately I didn't catch it in the reply brief, but the government cited it for another purpose in its brief. And Herrera-Pagoda at footnote 8 says very clearly, it rejects this exact same argument and says Palomar-Santiago didn't address this question, does not preclude this exact same argument. And so in Herrera-Pagoda and in Palacios Arias, which is another case that we've cited in the reply brief, this court did not treat Palomar-Santiago as any kind of bar to this kind of claim. So again, I apologize for not catching footnote 8.
This is just the procedural substantive line that you're trying to draw?
Yes, I think so. And in terms of whether a defendant can be excused at all from satisfying the exhausting administrative remedies.
Can you help me understand this? You just know these cases better than I do. It's a little odd to talk about this, and I know courts use the term excused, but it really seems like it's like satisfying, right? Like if he was denied the right to appeal, then in that sense, D1 is satisfied because there's no available review. Why do some courts seem to use the word excused when it really seems to me like what we're saying in all these cases is satisfied?
Well,
Do you see what I'm saying? Because the question is whether the right to appeal is available or not, right? That seems like a totally easy conceptual idea. But then courts say it's excused. What does that mean? Where does that come from? And you can say, I have no idea. It's our problem, not yours. But
well, my supposition is because it is a fact that he did not file an appeal. And so I think the courts have looked at that. Well, he is excused from having to do so because an appeal was not legitimately available.
But that's just D1 says, right, did he take advantage of all available, review, right? And so we're just asking the question of like whether it was available. I mean, it just seems odd to talk about excusing D1 and D2 when the analysis is plainly, it seems like to me, asking, was it available or not? And that is D1 itself.
I think that's correct. The one thing I would like to mention as my time winds down.
I wanted to ask you about D3, the fundamental unfairness. How, under what situation, based on with this criminal record, his, I think he would be applying for asylum 40 years later. Under what situation are you going to be able to get on that under fundamental unfairness? Would he be able to obtain asylum?
Well, partly we don't have a full record because he was never really afforded the opportunity to present the claim. So I can't say here today everything that he might have been able to bring forward. What I can say.
Wait, why do you say he wasn't afforded the opportunity to present the claim in the district court?
Well, if I may finish.
You certainly may, because I'm interested in her question too, and you will give you a full chance to answer it. But why do you say he wasn't afforded? I mean, you made the claim below. It seems like to me you had the opportunity to present it.
So what I'm saying is that if he had been, if everything had gone the way that we argue that it should have gone, he might have been able to present more evidence than we have at this point, but.
Present more evidence you mean at the original
Yes,
deportation?
that's
Well,
correct.
but
So-
D3 tells us that we've got to look at it in hindsight,
No,
right?
I understand, I'm just
Give up
saying.
all
that-
hope of a better yesterday.
No, I understand that, I'm just saying that I wish the record were fuller than it is now, but what we
Okay.
have.
Can you go back to her question then?
Right.
Yep.
On what we have on this record is that because of changes in the political circumstances in El Salvador, he alleged a reasonable, credible fear of being returned there, and
So
so.
that was in 2014, and he didn't apply for asylum at that time. So that's why I'm curious as to what support, what case law, what support do you have based on his applying 40 years later? If, let's say, we say that it wasn't valid and it was involuntary, when we get to this fundamental unfairness, how is he able to be successful in his asylum claim? With the criminal record, I think he had 4 DUIs, 2 of which were felonies, an identity theft. He applies 40 years later than when he's eligible to apply. What cases support for purposes of this fundamental unfairness? Because I believe he has to prove all 3.
Yes, that's correct. And so my argument there is that there's not a specific time bar under the claim that he can file for asylum within a, quote, reasonable period after a change in circumstances. Our argument is that he would be able to do so even at this date, and that a claim for asylum necessarily includes a claim for withholding of removal. An immigration judge is automatically required to consider that as well, and that's mandatory relief if the non-citizen meets the standard for that. It is a higher standard, but it's mandatory relief, and there's not an absolute bar based on his convictions. It's a factual bar that the immigration judge would have to look at the particular facts of those cases, and so just the fact that it's a DUI does not necessarily bar him, and so that's our argument. Now, we think that.
Can I ask you maybe a threshold question here? You mentioned Herrera Pagoda earlier. It seems to suggest this question that you've raised about developing the record on asylum is not a constitutional claim at all. It doesn't seem to suggest that. It actually says there's no constitutional right to be advised of eligibility for discretionary relief. So how can we look at that for a D3 purposes at all?
Our argument there, Your Honor, is that because an asylum claim also necessarily includes a claim for withholding of removal, which is mandatory relief, that wouldn't apply. And also that.
Wait, so in other words, Herrera Pagoda is wrong because they failed to recognize this sort of implied inclusion of a different claim?
Well, it's not implied. It is explicit under the immigration regulations that
No, but it's
immigration.
implied that it's included within the asylum claim.
Well, and I'm saying it's explicit. It's not implied under the immigration regulations. It's deemed to include, and so an immigration judge knows that if someone says asylum, they're also applying for withholding of removal, which is mandatory relief. But I think we don't even need to get there.
Isn't there also a reasonable probability that he could have been granted voluntary departure?
Well, we acknowledge that voluntary departure is discretionary. And so I think that.
But he could have been granted voluntary
Yes.
departure, even if he was denied the asylum claim,
I think that's correct. The
and
government.
wasn't allowed the opportunity to present that case.
That's correct. And I don't think we even need necessarily to get there because he would establish prejudice simply from being denied the right to appeal. That's our argument, primary argument there. So thank you very much.
Thank you, counsel. Mr. Day, happy to hear from you.
Good morning, may it please the court. I will just start on the fundamental unfairness prong to pick up where we left off. I do believe, As Judge Richardson noticed, that Herrera Pagoda says an alien has no constitutional right to be advised of his eligibility for discretionary relief. And I take a different view that asylum is a form of discretionary relief, and that's referenced in this court's decision in Meha versus Sessions at 866 F. 3rd 553 at page 578.
What's your response to his argument that the regulations tell the district court, or tell the immigration judge to also consider this other form of relief anytime an asylum claim is raised?
I understand that, Judge, but I think what the claim here has been from the start is the immigration judge's failure to develop the record with respect to asylum, not with respect to withholding of removal, which is a separate form of relief that the defendant could have pursued but did not. So on this record, what we're talking about is asylum, and that is plainly a form of discretionary relief. Herrera Pagoda answers the question of whether that's a due process right, and El Shami and this court has repeatedly said under D3 to show fundamental unfairness, the defendant must show not just some sort of statutory violation, but a due process violation. That's prong one. Prong two is that the defendant has to show prejudice. That means that but for the violation, there was a reasonable probability that the defendant would not have been deported. I think Judge Benjamin's questions about this one-year time bar and the fact that the defendant had multiple DUI convictions, including felony convictions and identity theft conviction, show clearly on this record that the defendant would have been barred from obtaining asylum even if he had shown an initial threshold eligibility. So,
And what about voluntary departure?
Yes, Judge. So I don't believe that developed that argument in the record, but I do think that Herrera Pagoda again plainly concludes, and Herrera Pagoda was in fact about the defendant there claimed that the immigration judge had an obligation to develop the record with respect to voluntary departure, and the conclusion there was that's not a due process violation even if there was such a failure. So here on this record, though, the immigration judge, in response to the defendant's request for voluntary departure, so the defendant did make the affirmative request, the immigration judge analyzed his DUI history, said you have multiple DUIs, I don't think you're a good candidate for that, and then the immigration proceedings went on. So there was a request, it was denied based off of the defendant's criminal history, which was extensive. Shifting gears a little bit, I do want to go back to the district court's factual findings, which is this court should review for clear error, as my colleague on the other side recognized. The district court...
Can you start with this Palomar Santiago argument? I'll give you the warning, I'm skeptical. But do you think Herrera Pagoda's footnote 8 answers it first? And then second, help me understand why you think a case addressing like a substantive challenge encompasses procedural challenges?
Yes, Judge, absolutely. So at the end of footnote 8, I was just looked at it, just said we declined to reach the issue. It didn't say that, resolve the issue one way or another. It just declined to reach the issue. So that's the first point about the footnote in that decision. A similar argument was on this distinction between procedural and substantive challenges, was addressed in Palomar Santiago itself. There, the defendant in Palomar Santiago did claim a substantive error on behalf of that the immigration judge made, but he tried to recast it as a procedural error, thinking that might gain him some advantage. The Supreme Court addressed that argument and rejected it. In essence, it said, when a defendant in a 1326 prosecution raises either a substantive challenge or a procedural challenge, both are challenges. And 1326, the language of in the text of the statute, covers all such challenges to the validity of a prior removal proceeding. And so the Ninth Circuit has explicitly found that as well, saying that Palomar Santiago did not limit its holding to an immigration judge's substantive errors. Just on this point, I would think it illustrates that there really is no difference between a procedural and a substantive error when it comes to availability. The defendant relies on Noreen versus Holder as to the validity of his waiver in immigration court. That was a decision that the Fourth Circuit made on direct appeal from the Board of Immigration Appeals. What it shows affirmatively is that Mr. Castro-Alemán could have been Mr. Noreen. So he could have appealed the immigration judge's appellate waiver to the Board of Immigration Appeals. And then if he got an unfavorable decision there, he could have appealed it to the Fourth Circuit. So he had appellate remedies available to him that he could have pursued, but he chose not to. Likewise, in this case, the defendant claims that the immigration judge failed to develop the record with respect to asylum. He relies on the Fourth Circuit's decision in Quintero. Quintero, again, was an appeal directly from the BIA to the Fourth Circuit. Again, affirmatively showing that non-citizens such as Mr. Castro-Alemán have pursued on appeal an immigration judge's alleged failure to develop the record. These aren't, the right to appeal in immigration court has been on the books for decades. This is not a game of hide and seek. Non-citizens with reasonable effort should know to pursue this right if they want to pursue it. But going back, if the court doesn't mind.
Can you answer the question that I asked your colleague, and you can say you have no idea, it's totally a fine answer. Why we talk about this is excusing compliance on D1 and D2 instead of like complying with D1. I mean, D1 asks whether it's available. All of the inquiry goes to whether it's available or unavailable. Why do some courts use the term excuse compliance when it really seems like what it is the alien, meeting the requirement of D1 by showing that they did everything that was available to them, not the things that were unavailable?
I understand, Judge. Yeah, I would be speculating. It might go back to the Supreme Court's decision in Mendoza-Lopez that decided that when a non-citizen is deprived of judicial review in immigration court proceedings, then they, as a due process right in a 1326 prosecution, have an opportunity for judicial review of the validity of those proceedings. That's generally the case the court cites when they go to when they use the word excuse. But I will say what Palomar-Santiago clarified is that there is no such excusal doctrine. What you need to do is start with the text of the statute. And not every invalid waiver will necessarily render an appeal right in immigration court unavailable. And I think that is where the cases that go with this excusal doctrine go wrong. Because, well, in this case, we have a valid appeal waiver. So it's clear on this record that not just were the remedies on the books for decades and generally available, but that this defendant knew that he had those options. But if there were such an invalid appeal waiver, I think that, it would be an uphill argument, but depending on the facts and the circumstances of the case, an appeal right could still be available to a defendant. And so I think the excusal doctrines have been overruled by Palomar-Santiago. They were wrong. I think the question instead is whether or not an appeal is available to a non-citizen, as that term is used in 1326D1. The government argues that the term available should be afforded the same meaning as the Supreme Court's case in Ross versus Blake. Obviously, a different statute under the PLRA, but it analyzes the same term also in a mandatory exhaustion provision of the PLRA. I'll shift gears.
Yeah, you got anything else?
Not on Palomar-Santiago unless the court has questions. I'll shift gears then just to highlight the district court's factual findings and what it relied on. I disagree with my friend on the other side that this is an ambiguous record. I will acknowledge the compound question, and if it were just the compound question and simply the answer no, I think we would be in a much more difficult case, but we are not there. What we have in this record are multiple instances in which the defendant said, in sum and substance, what do I have to do so that you can deport me? What do I have to do so that I can be sent back to El Salvador? And the district court relied on those statements in finding that, quote unquote, critical context reveals that the defendant did not want to appeal. For example, after the immigration judge declined the defendant's request for voluntary departure, the defendant asked, what do I have to do so that you can deport me? That's a JA-36. And then after the immigration judge informed the defendant that he could appeal his removal order to a higher court, the defendant said, what do I need so you can send me back to my country? The district court judge didn't stop there. He looked at the broader context, facts, and circumstances of what was going on. This defendant had been in ICE custody for 6 months. He had faced lengthy removal proceedings that involve all sorts of investigations and inquiries. And at the end of the opinion, the district court said.
What about when his argument about this missing portion of the record, where he says, I have another question? I'm curious to hear your response to your argument regarding that. Does that change anything here?
I don't think it changes anything here because there's no evidence in the record that that missing portion had anything to do with waiver, first off. And what we do have that does address waiver is clear that the defendant didn't want to appeal, but instead he wanted to be deported expeditiously. And so if there were simply an allegation that, if there was no discussion of waiver, say in a different case, different hypothetical, no discussion of waiver from the immigration judge, the defendant didn't bring it up, and at the end, the proceedings were cut off, then we would probably be in a tougher case where burden might control. But that is not what we have here. What we have here is an explicit reference not only to accepting it as final, but immediately explaining that if you accept it as final, you will be removed, and then juxtaposing that option to appealing the removal order to a higher court. The defendant said, no, what do I need to do so that you can send me back to El Salvador? On this record.
What do you do with his multiple questions or statements about his inability to locate or put his hands on his father's death certificate? To me, that shows that he was confused and didn't know that he was asking questions about how to bring the asylum claim and was never told, well, you don't actually need a death certificate in order to bring that claim.
The government concedes that he did not actually need to bring a death
But he was never
certificate.
told that, right? In fact, he, on multiple occasions, stated he can't find it, suggesting that he believed that he needed it, and was never told, no, you actually don't need it.
That's correct, Judge.
So he believed erroneously that any asylum claim was foreclosed.
I don't know if that's true, and it's certainly not a factual finding that the district court found. Even if it were true, taking it at Your Honor's hypothetical, at worst for the government, that would be a statutory violation. Under Herrera Pagoda, he would not be able to show a due process violation. And for the reasons the government's argued about the one-year time bar and his particularly serious crimes, there's no way, even if he had presented an asylum claim, that he would have gotten asylum.
I understand that he would be unlikely to prevail on an asylum claim. The question really goes to whether he had waived, right? Because he just seems confused,
Whether he had waived his asylum claim or whether he had waived his appeal right.
his appeal right.
I understand. I will say there's no evidence that tying his lack of asylum to his desire to appeal. Like, in this record, he does not evidence a desire to appeal. He doesn't say, I disagree with you, Judge, or can I have more time? In fact, the immigration judge in this case offered this defendant, at the time a non-citizen, more time to apply for asylum, and the defendant said, I would rather go back to my country. What do I need to do to go back to my country? This was the second of two hearings that the immigration judge held. The first hearing, the immigration judge accepted the defendant's claim of fear, said, I will give you a few weeks to put your application together, made sure the defendant had the asylum application. The defendant never applied for asylum. He never submitted the application. I understand Your Honor's point that it might have been based off of some confusion, but he did not end up applying for asylum. Even so, the immigration judge at the second hearing said, do you need more time? The defendant said, no, I just want to know what I can do to be sent back to my country. So I don't think that there's any tying his potential confusion about the asylum process to a desire to appeal, because there is no evidence on this record that the defendant wanted to appeal. I will just briefly go to the burden of proof. I think regardless of which party bore the burden, the outcome is the same either way, based off of what I was just discussing about the validity of the appeal waiver. But I think the government urges this court to follow the First, Third, Fifth, Seventh, and 10th Courts of Appeals and a course of district court decisions in this circuit that apply the burden on the government. I think this flows directly from the text of the statute, as Judge Richardson noted, that the defendant bears the burden of proving each of 1326D's elements. It only follows from there, if he's seeking some sort of exception to those elements, that he ought to bear the burden of proving an exception. And I do want to highlight what the Fifth Circuit recently highlighted in its terms. A contrary holding would irrationally bifurcate this statute and the burdens of proof. So, and that this issue is presented squarely here in this case. The defendant here claims that his alleged invalid appeal waiver allows him to be excused from D1 and D2, and that the government should bear the burden of proving the validity of the waiver under D1 and D2. At the same time, the defendant claims that his invalid appeal waiver is one reason that he's allowed to satisfy D3. Under the text of the statute, the defendant clearly bears a burden of proving D3. So, in other words, he bears the burden of proving the invalidity of the appeal waiver under D3. So, if the court were to adopt the defendant's approach, it would be applying two opposing burdens of proof to the same issue under different prongs of the same statute. That approach isn't supported by the text of the statute, and I think it's contrary to common sense. Unless the court has any further questions, I'd ask that the court affirm the district court's decision.
Thank you, counsel.
Thank you.
Mr. Bryant, we're happy to hear from you.
Thank you, Your Honor. Just a couple of points very briefly. I think the government places too much weight on Mr. Castro-Alamon's statements at the removal hearing about the logistics of getting back home and does he need a passport. All that shows is that he's concerned about the next steps. And as the analogy that we put in the briefing, if someone at a criminal sentencing is asked the same compound question about accepting the result or appealing it, and the person just says, well, you know, are you going to take me to prison? Do I have to show up myself? That doesn't necessarily indicate that they accept everything that's happened. And it's also not, at least to an uneducated, uncounseled non-citizen, it's not necessarily inconsistent to think that they would be deported but still be able to appeal. It doesn't necessarily follow that he thinks that by submitting to deportation that he's foregoing any other claims for all time. One other thing, a couple of things that I would just like to note is that not every case that raises this issue is going to present these transcribed removal hearings in front of a judge. A lot of these cases are going to come out of the context of a very quick, stipulated signing of a piece of paper at the border or at a detention facility with a Border Patrol officer, perhaps. And in those situations, it would, as the Ninth Circuit said in the Gomez case, skew the government's incentives and create an insurmountable hurdle for the defendant, to put the burden on the defendant to say, oh, that waiver's not valid when the government presents a signed piece of paper, because it would really be impossible for the defendant in that situation to track down the evidence and call the officer to account and to contest all this, when it would be very easy for the government to do so. And it creates the incentive on the government to make sure that there's no confusion whatsoever. And this is why I think Judge Berner's questions are apt, that there is confusion replete through this record, and it's hard to read the transcripts of these hearings and come.
But you would agree on that issue that the IJ offered him, I think, an additional 2 weeks after, and this was, I think, the second time?
He did, but he also said that he had to complete the asylum application in English and submit it by fax, which is a high hurdle for this person to meet. But also, he could have given him 2 years instead of 2 weeks, and he wouldn't have been able to do it because he didn't think that he had what he needed to do it, and the immigration judge never told him otherwise. I think that really ultimately where we come down on the burden issue is that if this record isn't enough for us to meet our burden to show that the waiver is invalid, it's hard to imagine what evidence would be where there was not a clear question, there was not clear advice about the consequences and the availability of appellate review, and there just wasn't a clear answer that something that the government could have cleared up at the time. And so it's not incongruous under the law to have shifting burdens in certain circumstances, and we argue that this is a case where that should happen. And unless the court has any further questions.
I do have one more question.
Yes.
On the fundamental unfairness, you earlier said that on the that he could potentially apply for withholding of removal. Was that argued below?
I don't believe it is, but I believe it is implicit within the asylum claim. It is a necessary adjunct, and so if he had been able to apply for asylum, that would have necessarily included a claim for withholding. So that's how we argue we satisfy that. Thank you, Your Honors.
Thank you, counsel. We will come down and greet counsel after Ms. Edwards closes us out for the day.
This honorable court stands adjourned, signed die. God save the United States and this honorable court.